Hello and welcome to another one of our Newman short video series. My name is Jenny Watkins and I'm a lecturer in law at Newman, and today I'm going to be discussing the legal history and changes over time in relation to LGBTQ plus rights in the UK. The reason this specific topic has been chosen for this month is because, as you may know, February is LGBTQ plus History Month, or at least it is in the UK. In various other countries it takes place in October to coincide with National Coming Out Day. The reason it is February in the UK is predominantly because it coincides with the repeal of Section 28, and I'll be explaining what that is during this presentation. The main reason that this recording is a brief overview is because this is a topic that could simply be endlessly spoken about. LGBTQ plus rights, and particularly how they've changed over time, is relevant to a number of areas of law and also obviously society. But in terms of law, it's relevant to criminal law, it's relevant to family law, land and property law, employment, equality and discrimination law, for example, are just a few of the short topics that we could branch into. But for the purposes of today, we're just going to have a look at a brief overview and the history and how things have changed over time, and perhaps where there might be some gaps in the law as it stands today. So going back a fair amount of time, and I mean we could go back significantly further in terms of the development of LGBTQ plus rights, particularly in relation to criminal law. But the main sort of starting point that we're going to speak about really is the 1500s. So in 1533, King Henry VIII passed what was called the Buggery Act 1533. And what that did was it made sodomy punishable by death. Now, it took actually until 1861 for it not to be punishable by death. Ultimately, the Act was repealed and replaced by the Offences Against the Person Act in 1828. But as I've said, it still took, many further years before the death penalty to actually be abolished. So we can see from this sort of societal views, particularly of homosexuality at the time, feeling that it should be punishable by death, and it taking a significant amount of time for that to change. And then if we look to 1866, so effectively here marriage was defined as being between a man and a woman. In the case of Hyde and Woodmansey, Lord Penzance said that marriage as understood in Christendom is the voluntary union for life of one man and one woman to the exclusion of all others. Now that effectively became the definition, or the accepted definition, of marriage for a significant period of time, and effectively prevented the possibility of same-sex marriage happening any earlier than it has done. Interestingly, if we move slightly further on into history and we look at 1885, here Parliament passed an amendment for the creation of the offence of gross indecency for same-sex male sexual relations. And what that effectively did was meant that any form of sexual behaviour between men would be able to be prosecuted. Now, at this particular point in time, lesbian sexual relations were not actually subject to the law, and this is mainly because it was actually considered inconceivable as a concept at the time, and therefore it was not felt that it needed to be legislated on. And this continued to be the case for a significant period of time until we hit 1956, where the Sexual Offences Act then recognised the crime of sexual assault between women and considered it again to be sexual assault. So you can see from particularly the early years that the rights of LGBT individuals were almost non-existent, to the extent that any action was able to be prosecuted in the courts, and therefore that reflects societal views at the time of those individuals. then along came the Wolfenden Report, which was in 1957. Now, this is seen as quite a big step and a substantial change in terms of the development of LGBTQ plus rights and laws in the United Kingdom. Now, the report was considered to be groundbreaking. The reason it's called the Wolfenden Report is because Sir John Wolfenden was the chair of the commission that produced the report. But what the report effectively did was it recommended that homosexual activity between consenting adults should be removed from the domain of criminal law, and that actually there should not be legislation in relation to the private consensual behaviour of individuals. Now, whilst this is clearly a positive step, ultimately the report still supported the criminalisation of any public actions or acts or behaviour, and also its definition of what was considered to be private was quite narrow and quite limited. And what this actually meant that ultimately homophobia was still largely widespread and largely unchallenged in society. So a full decade after the Wolfenden Report, we finally see some legislative progress. In the Sexual Offences Act of 1967, and what that effectively did was decriminalise homosexual relations for men aged 21 or older in private. Now, private, again, is very narrowly defined, and whilst this legislation was considered a positive step, ultimately it was considered more an act of pity, actually, rather than empowerment of LGBTQ plus individuals. The age of consent still remained at 21, which was 5 years more than that of heterosexual activity or sexual activity. However, it was a positive step in terms of the criminality aspect, but also the act was almost a stimulus for activism, particularly in the 70s and into the 80s. But one particular event which you may be aware of is obviously in 1969, what's called the Stonewall Riots, more commonly. The Stonewall Inn was a gay bar in Greenwich Village, which is in Lower Manhattan in New York. The police raided it in the early hours around 1 a.m. With some staff and also some undercover officers inside. But the raid itself didn't quite go as the police had planned, and the patrol wagons who were meant to be arriving to transport arrested individuals were late, which led to a significant crowd growing, and this lasted for around 45 minutes with some police officers actually stuck inside. And what this event led to was a series of further demonstrations against this kind of activity in protest. And this series of events is commemorated by many annual Pride events, mostly taking place in July in the USA, but in other months across the world. And this led to, in the 70s and 80s, various organisations being developed across Europe and also internationally to begin campaigning for legal and social reforms to help protect LGBTQ plus individuals. As we move into the 1980s, HIV and AIDS became a bigger concern, and in the early 1980s, gay men were asked not to donate blood at all. Furthermore, Margaret Thatcher and her government, in the Conservative Party conference, she made a statement, and the statement actually said, children who need to be taught to respect traditional moral values are being taught that they have an inalienable right to be gay. And that was quite a controversial statement, or it is considered to be now, but perhaps not so much at the time. Following on from this, the Thatcher government introduced Section 28. Now, Section 28 you may well have heard of. And essentially what it said is that local authorities weren't allowed to intentionally promote homosexuality or publish material with the intention of promoting homosexuality. So it effectively put a large block on local authority involvement with individuals, and also in terms of education. It was quite a large block. So then, as we move further into the late 80s, early 90s, we have the setup of Stonewall UK, specifically designed to oppose Section 28, but also other gaps in equality. And it's only really in 1994 we start to make more positive progress again. So, whilst the proposal to lower the age of consent to 16, in line with that of heterosexual acts, was defeated, ultimately the age of consent was lowered to 18. So whilst it wasn't what was proposed by Conservative politician at the time, Edwina Currie, there was still a step, but ultimately it still left a gap in equality. And then we hit the 2000s. The first major change in the 2000s was that the ban on homosexuals serving in the armed forces was ended by the Labour government at the time. But this wasn't necessarily or particularly voluntary action. It was predominantly due to the fact that the European Court of Human Rights ruled it unlawful to allow that ban to exist. And then in 2001, the Sexual Offences Amendment Act lowered the age of consent for both male and females to 16 to be in line with that of heterosexual acts. Then as we moved through the 2000s, we hit 2003, which is a landmark year in terms of rights and changes, in that Section 28 was repealed. This was considered, and is still considered, a significant event, and is one of the main reasons that LGBT Q plus History Month began on the anniversary of the repeal of Section 28. In 2004, we had some further major legislation in terms of the Civil Partnership Act, which afforded same-sex couples similar but not the same rights as those non-same-sex couples who were married. And we also had the Gender Recognition Act, also in 2004, which finally gave legal recognition to trans individuals and enabled them to legally change their gender, albeit through quite a difficult procedural framework. And this is an act that has been under quite wide discussion, and particularly in terms of its reform very recently. In the second half of the 2000s, we had some further legislation. So we had, in 2005, the first opportunity for also unmarried couples, but for same-sex couples to be able to adopt children. This is also a landmark piece of legislation. And then in 2007, the Equality Act sexual orientation regulations became law, and what they effectively achieved were to make discrimination on sexual orientation in the provision of goods and services illegal. Furthermore, towards the end of that decade, Human Fertilisation and Embryology Act came into force, which had the effect of offering equal access to presumptions of parentage in IVF cases, and was designed to do many things, but also to equalise the treatment of situations where there are two females undertaking IVF together. However, whilst this point there have been numerous positive steps, at that point is still many gaps in the law and continues to be so today. But also, it didn't just mean that society's attitudes just changed at the drop of a hat. It's an area that has been involved in a wide range of discussion. And if you look at 2010, particularly, religion in the past has heavily clashed with the rights of LGBTQ plus individuals. In actually 2010, on the Pope's visit to the United Kingdom, he said that effectively the law was running contrary to natural law, and in fact that, you know, affording LGBTQ plus individuals additional rights was not a natural thing to do, which, you know, I'll speak about in a moment. But, you know, religion and the rights of LGBTQ plus individuals, you know, have clashed and continue to clash, and are likely to do so in the future. And then also in 2011, we had a slight change in that gay and bisexual men weren't completely banned from giving blood anymore. But that being said, they did have to wait a full year of non-sexual activity to be able to give blood. So as we then move into 2014, arguably one of the biggest changes in recent history is the same-sex marriage introduction, which obviously effectively allows same-sex couples to get married in the same manner that opposite-sex couples have been able to do for a significant period of time, and that is a particularly landmark piece of legislation. Then we have in 2017 Policing and Crime Act coming into force. You may have heard of the Alan Turing Law more commonly, which effectively gave posthumous pardons to several thousand homosexual men who'd formerly been convicted. And it also allowed those who were still alive the opportunity to clear their slate, if you will, in terms of their conviction record. Then, as we move into 2019, we have quite a significant event, particularly in Birmingham, in terms of the No Outsiders debate. For those of you that aren't aware of this, effectively what happened was that there was a primary school in Birmingham where a scheme or a subject effectively utilised books and other materials to help children to understand inclusivity, including that of LGBTQ plus individuals. The lessons were designed to support inclusivity and to encourage students to be respectful and understanding of those who might be considered to be different. Now, it was done through a format of various sort of storybook type activities with animals and etc. used to explain characters. But what actually happened was that a number of parents were very unhappy with this teaching, and numerous parents and also local religious leaders got into quite a significant debate with the school, and it actually led to protests at the school gates. This went on for a significant period, and ultimately injunctions were required simply to make access to the school, the gates and entrances, safer and easier for children and teachers to get in. This is another example of the clash of religion and the LGBTQ plus community rights, effectively. Although it was a fairly local issue initially, it attracted quite a lot of national press, and actually the structure of the sessions and the content, the head teacher involved is now actually training others on how to use the content around the country. So actually it has become a national concept effectively. And ultimately, this clash is something that is likely to continue to happen in the future, and that there are likely to be other similar incidences in society. So then, as we move into 2020, we have quite a significant Supreme Court decision. This decision was in relation to children and their ability to have informed consent in relation to treatment. And this landmark decision particularly obviously affects young children, particularly with gender dysphoria, and also any individuals who utilise puberty blocking drugs. Effectively, the Supreme Court suggested that children under 16 do not have the requisite level of informed consent, which is an interesting decision, because if you look at other cases historically, the court looked at what's called Gillick competency to enable them to assess whether a young person is capable of having the appropriate level of informed consent to make big decisions in their life. In the past, for example, they've considered particular types of medical treatment and contraception, just as two examples. And yet in the Supreme Court case, it was held that the children do not have the requisite level of informed consent, which affects a significant number of young people in a negative way. And it will be very interesting to see how this decision develops in the future. So, this is after quite a few positive steps that we've discussed. This is arguably a big step backwards in terms of rights of individuals. Well, then moving into the very recent landmark events. So from this summer, gay men will be able to give blood if they've not had intercourse for 3 months or have had the same sexual partner for 3 months or more. So we've effectively progressed from a total ban to a long ban to a slightly shorter ban. So, whilst it's still not a equivalent right, it is still another step in the right direction, arguably. And also just last week, there was a new scheme announced by the Ministry of Defence, which allowed various LGBT veterans who were effectively expelled from military service to reclaim the medals that they were required to forfeit. So just in the recent history, but also over time, that you can see that there's been steps in arguably both directions. But ultimately, it can be said that there is still a significant way to go, particularly where in society LGBTQ plus hate crime still exists. It's still prevalent in certain areas and certain contexts. And we have various areas of the law where there can be considered to be gaps, and there are multiple areas that can be discussed in relation to this, whether it is the rules on surrogacy and how that might affect all parents, not just LGBTQ plus parents. The Gender Recognition Act, as I've mentioned, is arguably in serious need of reform. And we also have situations where, for example, two females who are married can't get a divorce on the basis of adultery because they cannot meet the legal definition of adultery in a divorce context. So that's just a couple of examples, and there are many, many more, and I could talk for a significant amount of time on that. But if you would like to continue the discussion, or ask any particular questions, you can get in touch. Our social media channels are on screen there for you. So both on Twitter and on Instagram, we are at Newman Uni Law. We also have the general Newman University social media channels, which you can utilise too. So that was a very brief overview into some of the key moments, or arguably key moments, in terms of how the law in England and Wales has changed over time and its effect on LGBTQ plus individuals. Thank you very much for your time, and if you do have any questions, please do not hesitate to get in touch. Thanks very much.